And to explain when the appointment actually takes effect, if we go back to the Articles 24.2, the appointment takes effect from the receipt of the notice.
Where's that?
Top of page 147.
Oh, I see, 24.2. Yeah.
Which is the way in which one has nominated.
It is exactly. It's the way in which they have nominated, but it then takes effect only at a point when that notice is delivered. There's limited value in any event about this comparative exercise that my learned friend went to, either in the new articles or in the BVCA articles. They were not the articles that the company had at the time. They can hardly shed much light on the position as it prevailed in March 2021. Instead, the distinction between nomination and appointment is manifest when one looks at the original articles of the company. I said earlier that these incorporate Model Article 17 of the Model Articles, and paragraph 1 of that article provides, and I'll read it into the transcript, any person who is willing to act as a director and is permitted by law to do so may be appointed to be a director, A, by ordinary resolution, or B, by decision of the directors. Those incorporated provisions of the original articles, indeed the original articles themselves, only talk in terms of appointment. They don't talk in terms of nomination. They provide, as I've indicated, through their incorporation of Model Article 17, a constitutional mechanism as to how this is to be achieved. And the nomination letter in our submission confirms only Magic's entitlement to nominate, a right that all members of the company enjoyed and could pursue. If that nomination was to be given effect, it would be given effect by either of the courses set out in Model Article 17.1, either by a decision of the directors or, if needs be, the proposal of an ordinary resolution. Now, as the judge noted at paragraph 42, Roman 3, core bundle, page 111 of the appeal judgment, plainly the expectation would be that Magic would receive serious consideration of its nominee. But it is evident that such rights would not be absolute.
You say not absolute. What right would there be?
Well, a decision, for example, that requires to be taken by the directors to appoint somebody to the board would activate their fiduciary duties and could not be expected to fetter those fiduciary duties in advance. So, for example, if the company were to propose, Magic were to propose as a nominee a particularly notorious individual, the company's directors, in the exercise of their powers, would be properly entitled to say, no, this is not in the best interests of the company and we reject it. Similarly, if Magic, that doesn't mean it's not receiving serious consideration. There's just reasons why that nominee would be unsuitable and should not be appointed. Another example, but focusing in on the position of the members. Well, clearly the members aren't bound by a letter written by Mr. Broadbent on behalf of the company. If they are to be faced with an ordinary resolution to appoint X or Y as a director of the company, that would be dependent on the members being satisfied that was an appropriate appointment. But I suspect based on what we've seen. The intention was that the serious consideration that would be given to any nominee by the board would be a basis upon which Magic could seek to give effect to the right that's recorded in the nomination letter.
Can I understand what the case is? Well, let's be absolutely clear. What, if any, contractual right is given to Magic?
It has a contractual right to nominate a director to the board.
Is any
Someone to the board.
correlative obligation imposed on anybody?
Well, there is a commensurate obligation on the company to consider that appointment in accordance with the constitutional framework of the company. I've indicated the provisions of Article 17.1. If it's the director's decision, and I anticipate it would go there first, the directors would have to give it serious consideration, but as I've just outlined, there may be circumstances in which giving it that serious consideration leads the directors to conclude that this would not be an appointment that they could endorse.
So can we just pause there? So you say there was an obligation on the company to consider an appointment in accordance with its structures. So when the matter goes to the board, any obligation on the board of any particular kind, or do they just say, well, do we think it's a good idea?
Well, that is, with respect, a bit of a simplification of the considerations the directors would have as a board in facing any decision of this sort. They'll have to consider whether or not it's an appropriate appointment in the interests of the company. They will, in doing so, have to act for a proper purpose. Can't just simply reach a decision to spite Magic, and they'll have to abide by their requirement to exercise independent judgment. I simply bring to bear the suite of fiduciary duties and statutory duties that directors owe in their consideration. The Singaporean appeal case recognises there may be circumstances where, even on the implied term that was found there would be considerations that could be brought to bear by the board in deciding whether or not to effect an appointment. And as I've indicated, the Court of Appeal approached it in that case on the basis that if the board were to to reject a nominee, the burden of evidential burden or legal burden would actually pass to the board to justify its decision.
So do you say it would be similar here, that the appellant would have a contractual right with a correlative duty on the part of the company to accept the person nominated by the appellant unless it was one of those two situations contemplated by the Singapore Court of Appeal?
Well, I think I've given a further example of a situation. I think the notorious individual example isn't quite the one that the Court of Appeal give. But in broad terms, my Lord, in answer to your question, yes, we would have to give serious consideration to it. If that meant there was a shift in the burden of proof to explain why the board turned down that appointee, or nominee, that would be something that the company would have to do. But we have never been faced with that circumstance. There has been no other activation of the right of the nomination letter.
I think one could turn that round and say, actually, you had effectively said there was no right. And so the position you're espousing now might be said to be inconsistent with the position you took at the time.
Well, what I will say to that is this. Mr. Broadbent questioned whether Magic had a wider right in the correspondence. I accept that. He has been found by two judges. First, finding that the right was a right to nominate rather than a right to appoint, and the second, that it was a one-off right rather than a continuing right, to have had genuine basis for questioning the right that Magic has sought to put before the court today.
I think Mr. Broadbent was suggesting that at the time.
Yes.
You've had your you've had your nomination. You had him. He's gone. It was a one-off, and there we are.
Yes, he's raised his doubt. He says, well, as far as it's not clear to me that you have a second right.
Yes.
He's putting forward a stance. He's not saying there in any way you have no such right. You're not going to exercise it. You're damned. That's it. He's questioning the right. He was being held entitled to question that right when one sees how the judges below approach that matter.
No, the point is that having taken that stance, at least I think that's my Lord's point, if having taken the stance that either you don't have a right or if you do it's a one-off right, it's now a bit different to come back and say, well, actually, we had a correlative, you had a right to nominate, we had a correlative responsibility to obligation to give serious consideration to your nominee, whenever that was, and possibly as far as accepting that the burden is on us to show why we are not appointing your nominee.
Yes.
That's much further than
I understand that.
the position that was taken at the time.
Yes. There are two answers to that. Can I just firstly distinguish? The points of defence are filed on behalf of Mr. Broadbent. I appear on behalf of Mr. Broadbent. I don't appear on behalf of the company on this occasion.
Yeah.
The us is the company would have that obligation. Mr. Broadbent has simply queried the existence of particular rights. He has done so in a way and presented his defence in a way that raises, as one often sees in defences, the layers of the onion, the various lines of defence that are drawn before Magic can win. This is not to say that if the court said, well, Magic would have to seriously consider and give serious consideration to any candidate, the company would have to give serious consideration to any candidate that was put forward on behalf of Magic, that gives rise to any unfair prejudice. There has been no attempt by Magic to put forward anyone else. This is a contractual obligation where its meaning is not clear. It was not clear to Mr. Broadbent at the time that he wrote his emails. It is, well, unfortunately, not clear given the stage in the appeal process that we're in and the slightly conflicting decisions we've had thus far and the points that are being put to me today.
When you say queried, you went rather further than querying, didn't he? I mean, for example, page 115 of the first supplemental bundle. Leave aside the defence.
Yes.
You're now suggesting that you have an ongoing right, which I don't think the original letter provides for. A board nomination isn't an appointment, and I can't see any reference to that leading to a second nomination after the first one. He's denying the entitlement. Now, in those circumstances, it's rather unreal to say that the appellant should have come up with a name and put it before Mr. Broadbent. He said, you haven't got a right to.
Well, my Lord, my submission, that's a rather harsh reading of this particular letter. Mr. Broadbent isn't a lawyer. He's expressing his view as to how he interprets the letter, and it doesn't provide an additional right.
It looks a very lawyerly paragraph, that one.
Well, my Lord, I'm not sure one can hold that against Mr. Broadbent as an inference, but it's
I think we can all agree that it's hardly encouraging Magic to come back with another name.
No, I can accept that, my lady. It's not encouraging Magic to come back with a name, But what
You're
happens...
even suggesting that it's open to Magic to come back with another name.
I'm suggesting that if Magic wanted to force this point, its obligation in order to be able to demonstrate any unfair prejudice would be to try and appoint somebody and see what the company does in the face of that nomination.
I think, Mr. Doty, you have to read the last paragraph on page 115, ignoring the last line, as well, looking back to try and better understand the background. You had specifically asked me to write the email below to you to set out my intentions. In it, I set out that we would look to appoint Chris to the board. There is no mention of alternative candidates, and that was never discussed. The email was accepted as the plan. So if you read those two paragraphs together, the impression is given that there is no right to come back. I don't think you disagree with that.
My lady, I don't...
But what you say is, as I understand what you say is, nevertheless, in order to show, to have a grounding for unfair prejudice, you'd have had to go and had it rejected.
Well, a letter written by one director, one shareholder in the company, back to Magic is not an act of the company per se.
I understand that, but that all of that is on the basis that actually Mr. Broadbent was the effective, let's put it that, face of the company, in the sense that he was appearing at least, and I'm not going any further than that, to write on behalf of the company.
Well, he's not alleged to have written on behalf of the company in any of these.
I'm just saying appearing.
Appearing, he was the conduit.
He's the conduit, let's put it that way.
Information.
And it seems the only conduit of information. Anyway, let's not get hung up on all of that.
I mean, the supplemental point, what's said on page 115 is very much what's pleaded in the defence.
Right, but let's go to the defence. Well, yes, the allegation there, though, in the defence, paragraph 24, company has failed and refused to permit the petitioner to nominate any other individual to act as director of the company. Doesn't reference any of this correspondence, but let's be expansive and assume that it somehow intends to incorporate it. It doesn't actually advance matters. It doesn't explain any attempts by the petitioner to nominate anybody for purposes of
True, but
subsequent
paragraph
appointments.
57, for example, I mean, that's echoing the letter. It's hardly encouraging Magic to seek to nominate anybody.
No, it may not have encouraged Magic to appoint anyone, but the only acid test that could be employed in relation to this was for Magic to actually try and nominate someone and see what happened. Magic didn't... This correspondence that you'll see peters out. At the start of November, the new articles and the deed of release were entered into, and we heard nothing from Magic, well, nobody heard anything from Magic on this aspect until the petition arrived.
And so, as I tried to summarise a little earlier, your point really is, in relation to this, other points, yes, that in order to show prejudice, you've got to have had a go and been rebuffed.
I don't know if it requires being robust. They should have at least tried... Rebuffed. I beg your pardon. Yes, yes, my lady. Because the prejudice that's complained of in paragraph 27 is the deprivation of an opportunity. And again, we have the word appoint here, which, as your lordships have my submission, Lords and Ladies have my submission earlier, about how the word appoint ought to bear the same meaning consistently throughout, and how the word nominate ought to bear the same meaning consistently throughout. Without actually having somebody appointed, or try and effect a nomination to lead to an appointment, and being rebuffed, Magic doesn't really get out of the blocks. Now, in terms of what Magic's right actually is, we say it's a right to nominate. We can accept for the purpose of this appeal it's a continuing right to nominate. And although originally it was a right to nominate to be given effect in accordance with Model Article 17, it later falls to be read against the background of the new articles, which offer the same opportunity to members to propose persons who can be appointed by directors or by an ordinary resolution of the company. Magic had recognised that distinction between nominate and appoint, as recorded in paragraph 23 and the second sentence of paragraph 24 of the ICC judgment. And in my submission, neither the judge nor Mr. Broadbent, the ICC judge nor Mr. Broadbent, can be criticised for having accepted the reality of that distinction. In terms of the factual answer to this complaint, it's absolutely common ground that the only person ever nominated by Magic was Mr. Mayor, and we've seen that he became, or was nominated by Magic from paragraph 23 of the petition in March 2021, in expectation of Magic's investment in the company. Now, we know from Magic's pleaded case, paragraph 23, from which Magic is respectfully tied, the petitioner nominated Mr. Mayor as a director, but that did not affect his appointment. I've referred to Mr. Mayor attending board meetings and the difference there is between the two sides as to whether or not he was actually appointed a director, but as I say, perhaps irrelevant. On the 11th of July, supplemental bundle pages 93 to 94, Mr. Mayor notified that the company and Magic, notified the company and Magic that he could not be a director of the company. And Magic knew from this date, as it was in copy, that it could not look to Mr. Mayor being its representative. The right to nominate on Magic's case rested with Magic. As my Lord Justice Newey said earlier, the exercise of a right to nominate, in the pure sense for which I contend, did not depend on anything being done by anybody else. It was within Magic's own gift whether or not it pursued that. And it's common ground, and we see that from paragraph 25, the ICC judgment, core bundle page 196, that Magic has never actually nominated anyone else at all. And that is true even through to today's date. My Lords, I've made the point about the email correspondence and the extent to which it should be treated as some sort of tablets of stone that enshrine irretrievably Mr. Broadbent's position and a denial of any right within Magic. And I won't endeavour to repeat that. But the broader context of those emails was, as I've said earlier, the amendment to the articles into what became the new articles and the entry into the deed of release. And Magic, for all its correspondence in late October 2021, and listened to a huge amount of it, did enter into a resolution adopting the new articles and the entry into the deed of release. And as I've indicated, this correspondence fizzled out. before the end of October, once Magic confirmed that it was going to enter into those agreements, those arrangements, the new articles in the deed of release. In my submission, and for the reasons given to Lady Justice Asplin in answer to a question, we submit that's not a prepossessing background to complain about unfair prejudice. It is a situation where Magic pleads nothing that shows that the exercise of its nomination right would have led to an appointment, or that that appointment would have ever changed anything. In our submission, the ICC judge was entirely right in her approach to this matter. Magic had a right to nominate. That was confirmed in the nomination letter. That right, if it was used, would have to take effect through the mechanism in Model Article 17, and in that, Magic was no different from any other shareholder. And that position applies now, even after the adoption of the new articles.
Can I just pause there? You say Magic was in no different a position to any other shareholder. I mean, that is your position. So the right to have somebody considered that you were postulating earlier doesn't really amount to anything, because it's in no different a position to any other shareholder.
Well, it amounts to something in itself, but it doesn't oblige the company to make the appointment. That's the distinction I'm drawing. One would expect, just as a matter of good corporate governance, that any company presented with a proposal from a shareholder would give it proper and due regard. It wouldn't be rejected for spurious or capricious reasons. But in that analysis, it makes entire sense why the nomination arrangement doesn't find itself in the subscription agreement at all. It finds itself in a side letter written to whom it may concern. That side letter, whether it takes effect as an agreement or otherwise, how much of an overlay it actually adds to the articles might be debatable, but simply entitles Magic to nominate a director.
Just circling back, does it give Magic anything at all by way of legal right? I mean, any shareholder can suggest somebody. They don't need this agreement to provide for that. Does Magic get anything out of this agreement?
Well, the question would only be this for the court, and it's probably one for this court rather than for me to say too much about. Did the mere fact that it was enshrined in a nomination letter elevate in some respect the expectation of Magic that it would be, that people it put forward would be seriously considered, such that it stood on a slightly higher plane than other shareholders in the company, who didn't have this letter written to the world capturing a statement that it had this right?
I thought we were getting close to the point where you'd accepted that there was a correlative duty on the company to appoint, save where there was very good reason not to.
No, I'm not sure my lady, I did go that far.
Right, okay.
Certainly didn't intend to. No, this is, I accepted that the company would give the matter serious consideration.
Yes,
but in
but
the
what
absence,
does that mean, really?
Well,
Scratch their heads very hard about it.
in accordance with their fiduciary duties, the directors would make a decision. Those fiduciary duties could be impugned, and then the court could look at those reasons why those fiduciary duties were exercised in the way that they were. That's a typical dilemma for the court when it's actually faced with the challenge to the exercise of the director's powers.
And you would say, I'm so sorry.
Sorry, go on.
And you would say that that was the same in relation to any shareholder who thought to make a nomination.
Yes,
Because
unless
if you put forward a nomination as a shareholder, you're entitled to have it considered by the directors seriously in accordance with their fiduciary duties. So it's
Absolutely.
absolutely no different. You say whether you are Magic and you've got the letter or you're not.
I would say that would be my primary position, unless this court were to conclude that the letter gave Magic some
elevation.
elevated expectation that something.
But what effect does an elevated expectation have? I'm not quite sure.
Well, I'm not sure how it would actually play out in practice. It's not a pleaded issue at all.
But
It would. I'm sorry, it occurred to me on my feet, and maybe it's not such a wonderful distinction. But I was simply contemplating that the fact that it's enshrined might, if a court were looking at an unfair prejudice petition, say, well, actually, maybe there was something more that was required of the company than in the run-of-the-mill case of a shareholder just popping something forward. Magic was an established international investor. Maybe there's something else that can be spelled out of it. My primary position is no, it's in no different position from any other shareholder. The recognition of and confirmation that it has a right, an entitlement, recognised in the nomination letter, is just simply a recognition of an entitlement that all shareholders have. It reflects Magic's pleaded case above all, and to allow it to effectively substitute the word appoint for nominate is to allow Magic to amend when there is no application to amend and
I mean, just talking around it for a moment, do you say, well, directors have to make the decision? Maybe one thing they should have in mind is that this letter has been written.
That's it.
And so it really doesn't matter whether the letter has any contractual effect or not, because if it does have contractual effect, it doesn't mean anything. There's no question of Magic being able to attack anything the company does contractually. It could only do so by seeking to challenge by derivative proceedings or somehow.
No, it could challenge in an unfair prejudice petition the decision that the directors have taken.
But it wouldn't be on the basis of a contractual right at all. The contractual,
no,
it would be a breach of fiduciary duty, or
exactly.
Yeah.
And so presumably you would say that those earlier emails about we need this because of South African exchange control, etc., are of no relevance because we're not construing a contract. Is that what you say?
Well, those materials are of no relevance because they're not actually put forward by Magic as qualifying its interpretation of the word nominate. On its pleaded case, as I've indicated, I've indicated the way in which Magic distinguishes between the words nominate and appoint.
Okay, I see.
There is not a pleaded case where Magic contends the word nominate means appoint because of the references in prior South African discussions with Investec. That's absolutely evident from what we've looked at this morning. Instead, Magic has advanced a case recognizing a distinction between nominate and appoint. It can fairly be held to that pleading. This is the third occasion it's being reviewed by the court. And if it itself draws that distinction, there is really no proper basis to attack Mr. Broadbent for taking points on the face of Magic's own case. It is the petition that was struck out by the courts below. It is the petition that defines Magic's arguments. And the scope, therefore, of what would be properly before the court at trial, until, just in answer to the question, until Mr. Lazarus's and Mr. Da Costa's witness statements, there was nothing about prior South African discussions being brought in to somehow qualify and enhance the right to nominate. We don't see that in the petition. It wasn't mentioned as a disclosure issue. It wasn't mentioned until the witness statements.
I mean, just breaking it down, I mean, you put your case various ways, but this one is you hold magic to its pleading. So first question is, how would the reasonable reader understand the pleading? And I have to say, I don't think the reasonable reader would think that magic was only alleging that it could suggest a name in the way that any other shareholder could suggest a name. But let's go beyond that. Suppose that we are concerned with construing a contractual wording. Well, there's no authority, is there, to say that you have to plead all the matters you rely on by factual matrix on a question of construction that I'm aware of?
No, but where you, in my submission, draw a sharp distinction between nominate and appoint.
So we're back to that.
We're back to that argument. You can't bring in factual matrix evidence and say, when I said white, I in fact meant black, and without amending my pleading, I can advance both. I can advance that argument about black, and that is our sticking point. Magic below, at the first instance, recognised the distinction between nominate and appoint.
You mean in the course of submission?
In the course of submission,
both words.
The judge records.
I really don't think that's going to help.
But my lord, the ICC judge, very experienced company law practitioner in her own right, and the appeal judge, both recognise the distinction between nominate and appoint. So they were reading the same petition as your lordship has. They have themselves reached different conclusions as to what it means. I appreciate your lordship sits in a higher court, but they are examples of putatively fair readers of this petition who have said, well, the case that Magic is looking to run is wider than the case that it actually pleads. And applying the principles I've directed the court earlier to from the authorities, that case wasn't open to Magic to run in the way that it has. I won't endeavour to repeat myself and say more to your lordship about the proper reading of the pleading, but I do encourage your lordship to reflect on whether the distinction that Magic itself draws is something that should be effectively allowing it to ambush Magic at trial that in fact it claimed to have a right to appoint. My submission, without amendment, Magic really doesn't get anywhere.
I suppose we need to move on to the rest of it, but you refer to being ambushed, and you say that it was recognised below that there was a distinction between nomination and appointment. Where do we see it being suggested before the ICC judge or before Justice Marcus Smith that it was not their pleaded case that they had a right to an appointment?
That was, can I take the judge first? The transcripts at page 527 of the supplemental bundle, tab 72.
Tab 62.
72.
72.
I'm sorry, on which page were we going to?
I beg your pardon, Melly?
Which page at tab 72?
I will...
Oh, sorry, I wasn't rushing you. I thought I'd missed what you'd said, that's all.
If your lordships go to page 117 of the internal numbering to the transcript, the new script.
One month 7.
117.
Yeah.
My submissions on the nomination continue into 118. I make the point about Mr. Mayor not being appointed by a nomination.
I follow all that, but I thought the suggestion was that it had been accepted by magic that their pleading didn't extend to appointment.
I think the closest you come to that on page 118, line 16, is you say that highlights and indeed, as Counsel for Magic accepted below,
Yes.
there's a difference between nomination and appointment. Was that what you were looking for?
Well, I was actually, I mean, the point can actually be taken from the ICC judge's judgment. I think it's paragraph 23. Oh, 24, I beg your pardon.
Sorry, I've lost it. Where should I be?
Page 196, tab 18, I beg your pardon.
Of what?
Call bundle.
The call bundle, thank you.
Which paragraph are we looking at?
Paragraph 24.
24.
In the second sentence, the judge records the absence of a dispute as to the different meaning of those two terms. Well, the context, then the first sentence, if that's what he wants. Sorry.
This isn't them. This isn't them saying.
Sorry.
The fact that they recognise that they can mean different things isn't them saying, "Oh, look, we were complaining about."
No, I'm sorry, my lord. It's picked up in the final sentence of that paragraph. I was only endeavouring to.
This is the judge's view of what the pleaded case is.
As well as what Mr. Head admitted
Yes.
was the petitioner's case.
Now, my lord, rather than use valuable court time, I will endeavour to find Mr. Head's admission overnight, and I will take the court to that, or direct the court to it. But that is consistent with my recollection of that hearing at first instance. If that is...
I know we ought to move on. I was just looking to see whether what was said in the skeleton argument for that hearing. So this would be page 361 in the second supplemental bundle, I think. No, that's your skeleton.
No, 361 is my learned friend's
It is yours.
Head's skeleton.
Oh, yeah, I see, yes.
But what Mr. Head says at paragraph 48 appears to be second sentence. That matters because Mr. Broadbent does not contend that Magic's rights in this regard would have been fulfilled if Mr. May had merely been nominated by it without ever, in fact, being appointed.
Not sure that makes a lot of sense to me.
Yep. Okay.
Anyway,
So
Mr. Head's skeleton on this point doesn't go into the nominate means appoint argument. That argument isn't there. The argument that was put by reference to the email correspondence with received, again, I'll direct the court to the transcript references for that, was that it was the denial of the right to nominate, in the purest sense, that was infringed by Mr. Broadbent's communications with Magic. And it's only with the notice of appeal to the judge that Magic has rebased its case without amending its pleading in order to say, well, nominate means appoint.
I'm sorry, I'm taking people back, but I'm still in that skeleton at divider 56,
Yes.
page 364, and although it's not entirely clear, I think paragraph 57 crosses the divide between nomination and appointment.
I think it, perhaps, my lady, it crosses the, addresses the question of whether or not the nomination was once and for all or could be repeated. It postulates the example my learned friend gave of somebody dying in office. Could it nominate a second?
Well, I'm looking at the reference to South African exchange control, and then the sentence which begins 4 lines down on the right-hand side. It's also inconsistent with Magic's understanding that it would continue to have a board representation.
Yes, this is addressing the once and for all argument, the one-shot nomination. I don't believe that paragraph is elevating is saying nominate means appoint in this case.
Okay. I'm sorry, I interrupted you.
No, my lady, that's. I'd rather answer any questions on the way through. Even if there was, and perhaps this is an embellishment on the point Lady Justice Asplin raised with me, there is no unfairness or prejudice to Magic. Even if there was unfairness or prejudice, the court concedes that there could be some. It was plainly so trivial and so limited in time that it should not properly be regarded as within this jurisdiction. The court will be aware from the citation given from Saul D. Harrison that trivial or technical breaches of the articles shouldn't be regarded as being within the jurisdiction of 994.
It becomes trivial, you would say, because it's only a right of nomination and everyone's got one of those.
And it's a right that was never actually asserted
Okay.
second time after Mr. Mayor had indicated he was no longer willing to be engaged. Although Saul D. Harrison is expressed in terms of trivial or technical breaches of the articles, it's, in my submission, a wider gateway point. Trivial or technical breaches of any sort shouldn't be articulated under Section 994. It is a significant jurisdiction, and it's an expensive jurisdiction. It should require some sort of proper complaint to be articulated, and that is not here. I put that point in alongside the point I will later go on and make about that the remedy that the court might order under 996 needs to be just and proportionate, not a palm tree jurisdiction. My lords, my lord and my ladies, I propose to move on to the rights issue, but I would prefer perhaps to assist the court on any points on the nomination agreement before I do so.
I suspect we've taxed you enough.
Grateful. The focus below, certainly before the ICC judge, was that the conversion of directors' loans into shares involved a breach of the second subscription agreement. And the petition describes that and complains about the so-called repayment of the principal founder loans. This was the only case over the rights issue that was argued before the deputy ICC judge by the very draftsman of the petition. And he did not seek to articulate some secondary case which attacked the premise and terms of the rights issue in any other respect. Now, the question of the repayment of the founder loans was resolved against Magic, and that's been upheld on appeal. It's not pursued before this court. But my Lady Justice May made the observation earlier that the repayment of the conversion of the founders' loans didn't provide new cash to the company. That's quite correct, but it nevertheless has an improving position on the balance sheet. The position that the founders had as loan creditors of the company becomes a subordinated position as mere members of the company. And the court will be aware from the Dear Investors letter from Mr. Broadbent to shareholders that the purposes of the rights issue were not only to raise new cash, 4 million, but also to raise, also to strengthen the company's balance sheet through the 2 million conversion. That was up to 2 million conversion. That was made entirely clear to all shareholders in the company. Now, before diving into what is said about the rights issue, what is not said about the rights issue is perhaps equally important. There's no challenge that the company genuinely needed to raise money, or the maximum amount that is sought to be raised, or the form in which it was to be raised. There's no challenge as to the purpose why the company needed to raise money. And there's no challenge to the fact that the company genuinely needed to raise money in the time frame that it did. There's no challenge that the company could properly look to raise money by way of an issue of paper, rather than just by way of debt, or a mixture of paper or debt. There's no challenge that it was known that Magic could not invest in the rights issue, or that it lacked the funding to do so. And above all, there is no complaint that any of the directors have acted in any way in breach of their fiduciary duties or their 174 duty. Now, we've set out in our skeleton argument the very limited relevant text that one sees in the petition to what has been styled by the judge below as the pure dilution allegation. Paragraph 25 of the petition, after a series of complaints in paragraphs 17 through to 21 about the alleged repayment of shareholder loans, complains about 3 supposed instances of unfair prejudice, of which, as my own friend accepted earlier, the June transaction is the pertinent one for this purpose. Now, the June transaction, as it is defined in paragraph 22, is in no way attacked as to the pricing of the shares. It is recognised in paragraph 20, or maintained in paragraph 26.1, that the price per share was less than the market value of the share. But Magic accepts that a discount could be applied to the market value of the share in order to encourage the rights issue to get away. Even if Magic proved its pleaded case in paragraph 26.1, that wouldn't of itself substantiate unfair prejudice. Indeed, paragraph 26 rather floats in the air because there was, as the court has found below, no repayment of the principal founder loans. So how do we read paragraph 26 in the light of the abandonment of the appeal, or any appeal against that? Well, in my submission, the complaint here on the pure dilution allegation, if it's to be made, is a very odd one. Without any direct challenge to the notion that the price at which shares were offered was wrongful, was an impermissible discount, or the like. Magic seeks to complain about the wider terms of the rights issue, but to direct its complaint not against all shareholders who benefited from the taking up shares in the new rights issue and saying that was wrongful, but simply against Mr. Dixon and Mr. Broadbent. Now, I've submitted already, this wasn't this pure dilution allegation, however it might be cast, isn't the case that Magic ran below before the ICC judge. It wasn't also a case that Magic suggested required any disclosure. You've been provided yesterday night with the letter where Magic abandoned the relevant allegations that it had originally put forward as being suggested issues in the DRD. There was therefore no disclosure on this issue, and as the court accepts, indicated in an argument earlier, this is an area where disclosure would be relevant to both sides. It was not the subject of any application for expert evidence. This court will be aware that where challenges are made to the issue of shares in a rights issue, that is commonly made out by way of expert evidence that seeks to demonstrate the extent of what has been pejoratively framed, the alleged undervalue. And we don't accept there is any admission of any undervalue. Mr. Haslam and Mr. Broadbent are merely stating that the company had to get away with this rights issue and fixed on a price that was, in their view, the best way to actually, the company directors fixed on a price which was, in their view, appropriately priced in order to get the money in that the company desperately needed.
But this is dealing with there are many ways of coming at an appropriate value for shares, aren't there?
Yes,
there's the, on the face of it, comparison with the value placed on it by a contemporaneous, actually you say not that contemporaneous, offer by another company. And there is the commercial value, given that you need to raise money, and there are all sorts of commercial considerations. But we're dealing with this at a summary stage. So all of this is,
of course, but
what you're saying about
stage,
whether or not it was a value.
The summary stage, of course, should understand the background and decisions that directors need to make in the context of putting forward a price.
Yeah.
And I will, without hopefully testing the court's patience, very quickly sort of deal with competing considerations.
Are you leaving the question of disclosure? Can I just focus on that a moment?
Please, my lord.
If you're not going to come back to it.
I can't promise I won't come back to it, but I won't. I prefer to deal with it now.
I was just looking at, this is tab 40, isn't it, with your supplemental materials?
Yes.
And in particular, if I've understood the position correctly, in the end,
In the end,
items 1 to 5 went.
yes.
Is that right? And also 10 to 13.
That's right.
And
There are
13
two 10s, but it's the second one that.
Oh, yeah, I see. Yes. So 13 has gone, which does bear on recognition of price being less than market value.
Yes.
You have still got in the first 10, which deals with the company's circumstances at the time of the issue. So obviously disclosure will have been given on that.
Mm-hmm.
What further disclosure might have been needed if it had been absolutely explicit that it was being suggested that the shares were being issued at an undervalue?
Well, if there was to be an allegation that the shares were to be issued at an undervalue, and that had been pleaded, there would have been a clear need to understand how the price was actually arrived at. Renumbered paragraph 10 doesn't address the content of the decision as to how the price was arrived at and whether or not it was an appropriate price.
And I mean, the answer may well be you just don't know. Do we know? Do you know? Does your side know what further materials might then have been disclosed, which were not in fact disclosed?
Well, what might have been required in consequence of that, as to testing whether or not what disclosure material had been put forward, would be materials relevant to the expert evidence that would be expected on this point, namely, looked at as a snapshot at the end of June 2022, what was the value of the company, or what is the financial position of the company?
And that ties in with your point. Well, if you're going to have this debate, you need expert evidence. But at the moment, we haven't got expert evidence.
No.
So supposing you can run the case without expert evidence, then there would still be questions of disclosure. So would there be any extra disclosure, or has it been given?
Well, disclosure will have been given, at least without application for specific disclosure under 10, but
yes.
Nothing has been given in relation to the value of the company snapshotted at June 2022.
No,
If the experts were to opine on what the value of the shares was, they would need to see that financial information in order to put that together. And that's another reason why we say this really isn't Magic's case. Never was. It's not actually, I mean, just to follow on from the disclosure points and the expert evidence point, Magic doesn't even address it in its evidence in a way that suggests it had an issue over the pricing. Pure material on the repayment analysis. I'm sorry to hop around, but Mr. Lazarus deals with it.
I mean, at the same time, one wouldn't actually expect the petitioners to have any very useful evidence on this.
Oh, no, my lord, that isn't really my point. My point is they make no observation about the price being improper.
Yep.
It's not as if the petition can be supplemented by some suggestion by the witnesses that this, and I'm not saying that's permissible, but it's not even here. Instead, Mr. Lazarus at paragraph 53 and the 54, tab 46 of the supplemental bundle 1,
What paragraphs of that are you?
53 and
53.
54, my lady.
Thank you.
This is all they say. Mr. Lazarus says, Mr. Da Costa says similarly little. Page 281, following tab, paragraph 73 to 75. Now, I suggested to Lady Justice May that I would offer some legal context on the issue of shares and the rights issue. In my submission, it's not done by a one-size-fits-all mathematical formula, and with respect to my own friend, the decision in Petty doesn't say otherwise. The aim for the company, if I put it in the abstract, normally measured by its directors, is to get the best price reasonably obtainable for the newly issued shares. There are synonymous terms that might be used, full value, or something of that sort. But there are a multiplicity of issues that factor into what the company could expect to obtain from shareholders. The amount of money that it seeks to raise, the wealth of the shareholder base, their access to ready funds, allowing them to subscribe, and the time that the money is needed within. The prospects of the company with or without the money. Is it an existential threat to the existence of the company, or is it simply going to pause its ability to move forward? All those factors, and no doubt many others, contribute to the assessment of what is a proper price, the extent of any discount, and therefore the pricing of the ultimate issue. Now, I accept entirely that in issuing paper, the company is going to want to obtain the best possible price. But the analysis that I've given already suggests that the company has, there are competing priorities. It wants to make sure that it raises the money, or at least as much money as it needs. Otherwise, the whole exercise is rather pointless. It needs to incentivize people to take money out of the safety of a bank account and put it into shares. And it will necessarily be a dilutive issue if people don't take up their rights. But it is an issue made in circumstances where most typically all shareholders have minority interests that are just simply standing to be increased if they take up their rights. There's no premium to be attached to the shares, and there's no guarantee that anyone will acquire a controlling stake of any nature just by taking up their rights in a rights issue. If all shareholders take up their rights, there's no change in the relative percentages. And the court will be familiar with those sort of concepts in the very common arguments one sees in 994 petitions between whether a valuation should be discounted or undiscounted. And these various competing factors would normally be expected to be weighed by the company directors under their general management powers. But the petition, as I've noted, contains no criticism of the directors' compliance with their duties or criticism of them for the price that they have arrived at. Mr. Broadbent is one amongst several of the directors. In all other cases put before this court, and indeed that I've found, allegations concerning rights issue or the selective issue of shares seek to impugn the actions of directors who have gone about that process, including the decision in Petty. Paragraph 15 of the decision in Petty makes very clear that there were issues taken by the petitioner. Quote the words used. No, sorry, it's not. Perhaps we start at paragraph 22.
Sorry, you'll have to give me the tab number again.
Beg your pardon, tab 9, I do beg.
Thank you. And it was paragraph?
22, page 158.
Thank you.
Just the first sentence of that paragraph, the petitioners had made averments as to the impropriety of the price that had been put forward in the rights issue. The board, in response, as one sees from the judgment, had simply not admitted that it had done anything wrong, and the court, against that background, felt able to go on and examine whether or not there had been unfairly prejudicial conduct. Paragraph 31 of the petty judgment records the recognition of some discount on the value of the shares being appropriate, desirable. Unless Magic actually challenges the price or challenges the propriety of the decision of the directors, no hint of either in my submission and the petition, Magic doesn't get towards anything that can justify or substantiate a complaint of unfair prejudice, make a complaint of unfair prejudice in respect of what's been styled the pure dilution allegation. What we do know from the evidence is that even at the price at which the shares were offered, the targeted raise was barely achieved. I'd said it wasn't achieved in my skeleton, and that's incorrect. Mr. Broadbent's statement refers to the 6 million target finally being met on the morning that the offer closed. And the court was taken to that this morning. Magic's case, in heavy reliance upon petty, accepts and inherently accepts that there could be a discount, and perfectly legitimately be a discount. In that context, even if it proved paragraph 26(1), that would not be unfair prejudice. There is no imputation about the rights issue or the terms upon which the shares were offered to members, or the price at which they were offered to members. Does not say there was no good reason as to why the price was set as it was, or explain why. And it is that case that I would, in my submission, describe as an ambush case, had there been an attempt to run this pure dilution argument at trial, and indeed to cross-examine upon it. There is
But it was run in front of Mr. Justice Marcus-Smith.
The pleading point was taken. It wasn't. The pleading just simply did not substantiate this case. The argument was made before Mr. Justice Marcus-Smith that that argument was available to the petitioner, and the judge had failed to deal with it because, in truth,
Yes.
In the light of the submissions she faced, she had not had it drawn to her attention by Magic's then counsel. But the correspondence with the court that my learned friend took you to following the delivery of the draft judgment very clearly shows that we recorded objections to the attempt by Magic to run this case, the insubstantiality of the pleading and how it could not possibly support the allegations that Magic seeks to make. Where we...
But you didn't say it couldn't be run at all before Mr. Justice Marcus.
No, we didn't say that. We wanted to show that we have a case on substance rather than just a case that's would be impugned as somehow being technical. But if one looks at how a case of this sort might be argued, one sees the relevance of the financial data concerning the value of the company, an examination of the director's decision-making in and about pricing the offer and in other respects, and that's a basket of considerations to be reviewed. And as I have submitted earlier, it would be almost invariably a case where expert evidence would be required.
The one thing, it was explained to us that this is going to be a 4-day trial. Was that intended to encompass everything, or only so to speak liability?
It was colloquially a split trial, but
yes.
Your Lordship will appreciate it. The first phase was to consider not only whether there was substantive unfair prejudice, but also the form of relief. If there was to be a share valuation, that would be dealt with at a second phase or remitted to an expert. So it was a... And one sees that in ICC Judge Greenwood's initial order.
Yeah.
In terms of the position we did take before the judge, we similarly objected to the notion that there was any admission of an undervalue. And we took that point very clearly in the correspondence. The judge recorded in his judgment that there was an active issue as to whether or not that was maintainable or demonstrable from anything that had been put forward. We say it's clearly not. And it's clearly not in a context where there is no case to which it attaches. There's no complaint of an undervalue in the petition. The Brewdog deal, while superficially striking, isn't itself a ready comparator. The Brewdog deal was an indicative offer. It's made in a context that ignores the cash runway that the company had as of June 2022, 4 weeks as put by Mr. Broadbent, and it ignores the effect of the product recall and the disruptive effect that it had on the company. It's all very well to say a company has massive contingent value, but unless and until a deal is consummated, that can't be banked. And in any event,
something's only worth what somebody's prepared to pay for it.
And actually pays for it.
And actually pays for it.
Yes, indeed. Yeah. And moreover, the company had to survive in order to consummate the Brewdog deal, if it was possible. It's no use relying on the aspiration that it might happen if the company falters into insolvent liquidation in the meantime. Now, the Brewdog deal has gone nowhere. I mean, Brewdog is now in administration. It's not going to go anywhere. But the mere comparison, as I put it in our skeleton, of apples and pears doesn't really serve to demonstrate the undervalue for which my learned friend contends. It's just a difference in price and approach. The company facing the rights issue has all the basket of considerations that I've referred to. In dealing with a third-party purchaser, the company's position is very different, and there may be reasons in the purchaser's mind why it is prepared to offer the price that it did, albeit only an indicative price. Unlikely, perhaps, that it would be going much higher, if at all. Magic tries to rely, and we've seen it today, on what it might be able to achieve through cross-examination or submissions from documents. That is, in my submission, irrelevant if there's no case to which that material goes. And it would be an error, I would submit, on the part of this court to not recognise that the petition ties Magic's hands. Had Magic turned up at the first day of trial, putative trial in this matter, and said, "Oh look, we have a secondary case in relation to the rights issue," there could be no question that the court would allow that case to be entertained. There'd be no proper pleading of the case, no relevant witness evidence raising issues over the price, no disclosure, no expert evidence. We are, and the judge, ICC judge, was in essentially that position 4 weeks out of trial, where Magic had not put forward any case and argued any case beyond the repayment of the founders' loans, which it took objection to, albeit wrongly. If Magic was to sort out this matter, it would not be a simple amendment, and we part company with the judge at paragraph 34 of his judgment, Core Bundle, page 109, when he suggested it might be relatively straightforward. An amendment would have to explain, or at least make the allegation that the price was improper, or the discount was unjustified, too great. It would have to particularise why that was the case, assuming that involved and impugned the decision of the directors of the company who had set the price for the rights issue. That would have had to set out, with the particularity that one expects of allegations of breach of fiduciary duty, what had gone wrong. It would have created a disclosure issue for the DRD, and I've indicated my Lord Justice Newey. It would be essential in that context to evaluate the financial position and value of shares in the company as at the date of the offer to dear investors. And fundamentally, it would be a complaint against the whole rights issue, the whole structure and pricing of the rights issue to all shareholders was wrong. Not the complaint that more narrowly focuses on just Mr. Dixon and Mr. Broadbent in paragraph 26, 1, itself predicated on a point that Magic can no longer argue. Far from the suggestion of the judge, this is a sea change in the complaint that Magic was looking to make. It hadn't sought disclosure on the issue, or it suggested there was any issue for disclosure on that issue. It hadn't addressed it in witness statements in any way, and it wasn't even argued by the draftsman as a maintainable point. My lords and ladies, before I move on, is there anything else that I might insist on the broader rights issue complaint?
No, I think we're done.
There are a number of other points that Mr. Broadbent relies upon. I've made clear that Section 994 is not about trivial complaints. In my submission, the complaints here, whether out of the nomination letter or the rights issue, are strained or indeed manufactured. They're not really substantive complaints, and they should not be regarded as within the jurisdiction, properly within the jurisdiction. There should be some sort of threshold justifying the exhortation under Section 994. Beyond that, whether or not the court grants any relief under Section 996 is a matter for the court determining that the grant of relief is just. That is reflected in the very language of the section itself. And that notion of justice inherently involves an issue of proportionality. I fully accept 994 is, in broadest terms, a remedial jurisdiction. But that shouldn't be taken too far. It's certainly not a penal jurisdiction. and it ought not to inflict a remedy on a respondent that is out of all proportion to any misconduct established. Here, the petition maintains no allegation of misconduct against Mr. Broadbent. It's not suggested that he has procured the company's breaches of contract or alleged breaches of contract, yet he is made the subject of a claim that he should purchase Magic's shares. And as the members of this court will well know, a share purchase order ordered against an individual is a matter of significant consequence for them and enforceable, if needs be, by way of bankruptcy proceedings. We say there is no good reason for targeting Mr. Broadbent. We set out the cases and principles in section H of our skeleton argument, paragraph core bundle pages 44 to 48. I should record in referencing those that I have made an error in paragraph 51.1. The quoted text there is actually from the F&C decision rather than from Gamla-Staden. But subject to that amendment, that correction, I would respectively adopt that analysis into these oral submissions. The deputy ICC judge dealt with these points at length in her judgment, paragraph 65 to 82, core bundle 207 to 214. That is, as I've submitted earlier, a judgment from an established company law practitioner. She clearly did not consider that it would be just and proportionate in all the circumstances to see any relief enforced against, made against Mr. Broadbent, and in my submission she was completely correct in that. The petition complains in paragraph 28.2 that the petitioner should be accorded such further alternative order as the court thinks fit. With respect, that isn't a catch-all that allows Magic to cling on to and sustain a petition just because it might get some lesser or very different form of relief. The company's unfair proceedings applications rules, tab 2 of the authorities bundle, require at paragraph 3.2 the petitioner to set out the nature of the relief that they seek. The quote from the Pedersen decision at paragraph 51.2 of our skeleton illustrates that the petitioner should set out that form of relief, and that if it is considered to be excessive, the court can strike out a petition nonetheless. Magic isn't entitled to see this petition kept on foot if it hasn't pleaded a merited case on relief, and my submission hasn't done so here. Finally, we turn to the offer letter at core bundle tab 20, page 207. Sorry, it's not the core bundle, it must be supplemental bundle 1. Sorry, I've got an error reference.
Is that tab 43?
Yes, Your Lordship, quite correct. 236. Supplemental bundle 1.
Yeah.
Now, this letter is dated 31st of July 2023, so it's round about the time that disclosure was being undertaken in the proceedings. A bit earlier. if one thinks about how the case has inevitably gone thus far, Magic has lost on the repayment of the founder loans. It has lost on the endeavours allegation. Those allegations are not appealed and won't be, can't be. Where it stands any chance of moving forward are on the two allegations before the court today. Considerable time has been spent in these proceedings in arguing the 2 points upon which Magic has failed. And yet when one goes to the offer letter, and the only criticism now maintained against it in my learned friend's supplemental skeleton, is that it didn't offer Magic its costs. Now, Magic wasn't entitled to its costs in respect to the two allegations upon which it has failed. It was putatively have failed on those allegations at trial. It has a hope, and only a hope, because of course the issues are live, that the court might allow some of the other issues, the two other issues argued today, to go forward. But the letter offered what was, at the time, I would submit, an eminently sensible way of resolving this case. The objective purchase of Magic's shares at a valuation determined by an independent valuer based on full disclosure of the company's financial information, and offering a drop hands arrangement in relation to costs would have been manifestly a better deal for Magic than the deal that it will end up with, having lost on these issues. And of course, at the date of this letter, we'd only just had the CMC, so pleadings had happened. The petition was a relatively short-form document, as been noted, and we'd had the directions hearing. There'd been no reply, no other substantive steps taken. The offer on costs is contained in paragraph 11 of the letter at page 242. The expert's cost left up to the expert, and then the parties bear their own costs. Now, if this offer had been accepted, Magic would have had its shares valued independently. It would have stood to receive the value, and it wouldn't have caused all the additional costs that have been incurred, including, as my learned friend Riley observes, the 4 days that we've spent arguing about the strikeout in various fora.
Presumably they'd have been, well, tell me if I'm wrong, I haven't looked at it properly. This would have been on the diluted basis. The shares would have been valued on a diluted basis or not?
No. You see, if one goes to page 240,
Yep.
the premise of the, in paragraph 2, the premise of the sale date is either a date at Magic's election, either before the dilution took effect, or it could take the date after.
Yes, I see.
So Magic had the best of both worlds. It just had to choose between them. Now, this court will be familiar with the guidance that Lord Hoffman offered in O'Neill and Phillips as to the formulation of offers of this type. This contains, in my submission, compliance with those principles. It's an independent valuation. It's based on an open. It's based on a fair date. Magic could elect between the two dates, before or after the alleged dilution. The expert would have access to pertinent information concerning the company's value. and there was an obligation contractually upon Mr. Broadbent to complete the purchase. So he was putting his head on the block had this offer been accepted. It isn't, in my respectful submission, a departure from the O'Neill and Phillips principles for Magic to be asked to bear its own costs of reaching the stage of accepting the offer. In terms of the litigation, it has failed on at least half of what it set out to contend, and in my submission, that was a fair deal and one which should have found favour with the court as an alternative basis for bringing this relatively small-scale litigation to an end. The court is aware of the relatively modest sums compared to the costs that might be incurred of the shares as indicated by their parties in their indicative valuations. My lords, my ladies, we say that is another reason why we are properly able to uphold the order made by the courts below, striking out this petition. If Magic had accepted this offer, it probably would have been much further ahead than it is in fact now. My lords, I hope I've covered everything, unless there are any questions.
No, thank you.
You may just take instructions.
Yes.
Very grateful.
Thank you very much. Mr. Besvelberg.
Thank you, my lord, my ladies. I'll address you first on the board seat allegation. It appears that, having thought the argument I was meeting was that I'm not allowed to run the argument I was allowed to run about pure dilution allegation, my learned friend is also saying now that I'm not allowed to run the argument about the interpretation of the board seat agreement that we argued before Mr. Justice Smith, which makes one wonder what his judgment was discussing and what we were arguing about. My submission, it is a crystal clear illustration of the approach that's adopted by Mr. Broadbent throughout, which is to try and avoid dealing with substance, and try and focus on arid, unattractive technical points. And the reason why he does that, of course, came out when he was asked about the factual matrix material, which I don't think he was going to mention. And his answer was the factual matrix material is irrelevant because it hasn't been pleaded. That is, if I may say so, a surprising submission. And my Lord Justice Newey made the point. One doesn't normally plead factual matrix material. And certainly there's nothing in the Chancery Guide, which I checked, that suggests that you are required to do so. In terms of what my learned friend says the agreement was for, I confess I'm a little bit unclear ultimately. It's accepted, I think, that there is a contractual right to nominate someone to the board. Those are the words he used, which is just what's in the agreement, which doesn't take us very much further. I think it was accepted that there is some commensurate obligation on the company to consider the appointment in accordance with the constitutional framework. Of course, the defence and the whole way this has all proceeded is that there is no right to do that. And it was a one-off right. The reason why we're here, part of the reason why we're here, is because of the continued denial of it. And of course, it wasn't and hasn't ever been the case of Mr. Broadbent to say, you have the ability, the entitlement to say someone else, and the company will give consideration to it. He said it's just there is no such right to do it. It's gone. And my submission, it's unreal to submit, if my learned friend was, that the right hasn't been denied. Ultimately, though, I think then it was said that we're in no different position to any other shareholder, so it appeared that we were perhaps backtracking from accepting that there was any right. ultimately, in my submission, there's clearly a real prospect of success on the meaning of the agreement, and the inability, of course, of Mr. Broadbent to have any answer to the factual matrix material proves the point, if I may say so. What was those said was that the complaint is trivial.
Just before you
Yes.
get to the triviality, how does let's step back a bit from the particular facts of this case.
Yes.
Say in absolutely unequivocal terms, by deed, a company contracts with an investor.
Yes.
To allow the investor to nominate someone who will definitively be appointed to the board.
Yes.
How does that interact with the mechanism for appointment that you find in the article?
Well, it might be, and I think this may be the position in the case from Singapore, is that the company has contractually agreed that it will procure the person to be on the board. And if the company doesn't do that, then the company's breached that obligation. In this particular case, at the time of the agreement, we had the shareholders agreement that was in place, which is in supplemental bundle 2 at tab. I think it's actually supplemental bundle 1, tab 2. Yes. This is the shareholders agreement that was in place. I think the company was at that time called Victor's Drinks Limited. You see that on page 1. And if one turns to page 40, return to page 49, supplemental bundle 1, tab 2, page 49. You'll see article clause 5 of the shareholders agreement that Mr. Broadbent and Mr. Dixon shall be responsible for the appointment of the board. So, of course, the agreement that Mr. Broadbent signed on behalf of the company can sit entirely alongside this. In fact, that's what was accepted. Because they can choose who's going to be on the board. They can give effect to the agreement. That's the mechanics. And I should just for completeness rather, at clause 19.1, there's the provision. This is at page 67. That if during the continuance of this agreement there shall be any conflict between the provisions of this agreement and the provisions of the articles, then the provisions of this agreement shall prevail. So that's in terms of mechanics. Move on to the triviality allegation or submission. You've already heard from me on the importance, and as the judge put it, of having the right to have influence over the composition of the board, and how the denial of such entitlements is capable of amounting to unfair prejudice. We've cited ABC chewing gum. I don't know whether you require me to show you where Mr. Justice Plowman discussed the importance of having a right on the board.
We've been referred to it. I don't think it's worth taking up
Thank
time.
you. I won't. Yes. And I've already made the point based on Hawkes and Cuddy that the suggestion that all directors owe duties to the company, so it doesn't matter whether your proposed nominee is on the board or not, and why that doesn't work, and that's wrong. You'll recall that I wasn't sure how my learned friend was going to put his case that the nomination agreement had been superseded. He didn't address it other than to say, well, then now you have rights under the new articles. There's no reference to any doctrine of rescission or so on. So I'm in some difficulty in dealing with that. What he did, of course, show you is that under the new articles, they continue to include Article 17.1 of the model articles, which my learned friend read into the transcript. that provides, I'm just going to find my note. Oh, Mr. Pay, who didn't plead the case before, has copies. May I hand these up? They're useful. They were read out to you. Article 17 is at the second page. Appointment of directors. 17.1. Any person who is willing to act as a director is permitted by law to do so, may be appointed to be a director by ordinary resolution or by decision of the directors. So here, because there's also, as you saw, the provision that the founder still had the rights, there were 3 different routes by which it could happen then. Or 2 different routes, by the directors as a board, by the shareholders by resolution, or by the founders using their own powers to choose. So the mechanics remain the same. The company could give effect to what it had agreed to do. There's nothing fundamentally or inconsistent with the position prior to then. On the pure dilution allegation, if I might say so, there was a little bit of moving around between different issues. There's the question whether the case is pleaded, and then the question is how the case is going to be proven at trial. We need to keep those 2 different issues separate. On the pleaded case, you have my submissions on that, and you have my submissions about it being too late to take the point. When my learned friend referred to the DRD, of course the DRD isn't a pleading, so what's in the DRD is not relevant to whether it's in the pleading. If it's in the pleading, it doesn't matter what the DRD says, because that's issues for disclosure. It's just what issues there might be disclosure about.
Yes, save that A, obviously, if something isn't in the pleading, what's in the DRD might matter. And B, if it's not quite clear what's in the pleading, it might matter what the parties have thought ought to be included in the DRD.
Yes. So if it's in the pleading, the DRD doesn't close down the pleading. If I'm right on my point that it's too late for my learned friend to now seek to prevent this court adjudicating upon our ground of appeal, then again, doesn't matter what's in the DRD. At most, the DRD might have been relevant to argument about what might have happened at trial, or what might happen at trial. I would just ask you to look at this, and my Lord Justice Newey, you actually identified the point. It's in Supplemental Bundle 1, tab 40. Issue 10, first issue 10, my Lord identified, page 206, was the company's need for cash by June 2021, what was it, and how urgent was it? And that reflects the point I made, that quite clearly in issue from the pleadings, and you saw in the evidence emanating from Mr. Broadbent's side, of why they did the share issue and for what purpose. And you'll also see that, my Lord, you referred to issue 13, and that was, did Mr. Broadbent expressly recognise that the price per share was less than market value? And we have the response of why this shouldn't be an issue of disclosure in the 4th column. This is from Mr. Broadbent and the company. No, not an issue for disclosure. This is a matter for cross-examination and interpretation of documents in the initial disclosure. So certainly the respondent's view that Mr. Broadbent was going to be cross-examined on whether he had recognised that the sale price had been less than market value. Now, my learned friend made a number of points about how he said one might try and prove whether there's been a breach of the director's duty to, prima facie duty, to get value for shares. And he said you can use different expressions for it, for what you should get, proper value. What he didn't use was the expression market value. And we know why, because the evidence of his client, or his client's supporter, Mr. Haslam, was that they didn't get market value, deliberately so. And that is, as I said in my submissions this morning, quintessentially an issue for trial. And in relation to that evidence from the witnesses about why they did what they did, the way that it was dealt with by my learned friend was to say, well, there hasn't been a proper allegation in the pleading. So it went back to a pleading point rather than being an evidence point. I move on then to the suggestion that the prospects of obtaining relief against Mr. Broadbent...
Just before you do.
Yes.
Suppose that we allowed the appeal and said, yes, well, you better have your trial for 4 days as soon as the court can manage it without any further directions at all. Could that work? I mean, could you really go to trial on the existing disclosure and evidence?
Part of the reason I pause is because I wasn't acting on the underlying matter. I wasn't going to be briefed for the trial. I'm looking at it from a somewhat one stage removed. It could go to trial. Whether it would be a perfect operation if there isn't the possibility of further directions and for the parties to take stock as to what, if anything, further should be allowed. I'd be reluctant to say that there shouldn't be some opportunity for that, partly because I don't know whether I'd be letting my own client down by saying that, my lord. But certainly, for example, in relation to the board seat allegation.
No, I follow that.
Yes.
But in relation to dilution, relating that back to what was before the ICC judge, which is 4 weeks out from trial,
yes.
The evidence is in, seemingly, the disclosure has been given, seemingly. The submissions made by counsel then acting on your side rather confirm that he didn't have in mind the pure dilution allegation. And suppose now, immediately at that stage, there's a change of counsel. They say, no, we want to run pure dilution in the form in which you're advancing it now. How would that have worked? I mean, might not the other side have said, this really isn't fair. We didn't know that it was going to be run this way.
So I'm unpackaging that. If I might take a run up at it this way. Of course, if I'm right on the board seat allegation, it was wrong to have vacated the trial, so we need to have a trial. And so whatever issues there may be relating to this allegation can now be addressed so that we have a proper contestation of the relevant issues so that justice is done between the parties. And we'd say that that's happened because Mr. Broadbent wrongly sought summary disposal of the entirety of the petition. As regards the question that my lord asked me, just focusing on the pure dilution allegation, I say this slightly wryly. I don't know if we can be sure what position Mr. Broadbent would have taken, because, of course, Mr. Broadbent didn't think he could take a point before Mr. Justice Marcus Smith to say that the point wasn't arguable. He does now, full-throated now. I think it's, if I may say so, it's difficult to speculate whether he would have felt able to have that argument and what decision would have been reached on what the pleading said and whether it needed to be amended and whether it could be done in time. And the reality is that we haven't had the trial. I hope that answers the question, my lord. I'll move on then to the suggestion that raised in the Respondent's notice that relief against Mr. Broadbent is so fanciful that that is an independent reason for the petition to remain struck out. In our submission, it's clearly not a point suitable for summary determination in a vacuum without the benefit of the court's findings. I already made the point that insofar as the contention is that the pleading doesn't allege that Mr. Broadbent was concerned in specific matters, that is an arid and technical ground, which the judge said at paragraph 24 wouldn't be a good reason to strike out the petition or to allow it to remain struck out. And of course, petitions or pleadings are supposed to plead facts, not arguments. As to the legal principles, I just want to show you, if I may briefly, F&C Alternative Investments, Authorities Bundle, tab 11. Given the time, and I've got the references and skeleton, I'll just take you to one paragraph of the decision of Justice Sales, as he then was, page 262. Paragraph 1096. It's the second sentence. In my judgment, the test is whether the defendant in a Section 994 claim is so connected to the unfairly prejudicial conduct in question that it would be just, in the context of the statutory regime contained in Section 994 to 996, to grant a remedy against that defendant in relation to that conduct. Standard of justice to be applied reflects the requirements of fair commercial dealing inherent in the statutory regime, that is to state the test at a high level of abstraction. In practice, everything will depend on the facts of a particular case and the court's assessment whether what was done involved unfairness in which the relevant defendant was sufficiently implicated to warrant relief being granted against him. We've also cited the Privy Council decision in Min Siu Hung and the judgment of Lord Briggs. This is at tab 20, again, just one paragraph. It's at paragraph 14. This is on appeal from the Eastern Caribbean Supreme Court. So it was strictly under the terms of the Act of, I think, the British Virgin Islands. But in paragraph 12, it's explained that the jurisdiction there derives from the similar jurisdiction in the UK. And in paragraph 14, it said, there was likewise little disagreement between counsel as to the following principles. First, at the remedy stage, the court is entitled to have regard to any aspect of the facts as found about the history of the company and the relationship between its shareholders inter se and between them and the directors, including those occurring after the issue of the claim and those which may fairly be found by the court even though not necessarily pleaded. In short, nothing is off limits, subject only to the twin tests of relevance and weight in relation to the choices to be made in the exercise of the discretion. Secondly, the court necessarily looks not only to the past, but to what the court finds is likely to happen in the future. The final authority we cite is a decision of Mr. Justice Voss, as he then was in Apex Global Management, which is at tab 13. And at paragraph 114, which begins at page 310, the judge begins a survey of a number of authorities. We don't need to go into them because he provides a helpful and pithy summary at the end. But if we just turn over the page, just look at paragraph 117, its particular pertinent, it's a reference to the decision in Supreme Travels Limited and Little Olympian. And midway through, you'll see Lindsay J. held that section 459 and 461 conferred the widest jurisdiction on the court as regards parties against whom relief could be sought, and that in appropriate case, relief could be sought against a non-member or against a person not involved in the conduct complained of, at least if the person could be affected by the relief sought. And this was followed in Lowe and Fahey. And over the page, paragraph 125, I should say 124, he cited from F&C and the point I just showed you. And then he set out a summary of, in 125, these authorities all speak with one voice. Essentially, that it's a wide and flexible remedy, etc. The reasons why I show you those is to demonstrate that the suggestion at this distance that Mr. Broadbent would walk away scot-free, irrespective of what findings the court might reach upon the allegations if it were tried, is, in my submission, optimistic at best. Mr. Broadbent had a central role. He was the director of the company and a founder. He signed the board seat letter. He sent the emails denying the right to appoint. He's continued to maintain that position. He was the architect we've seen of the June 2022 transaction. He benefited from it. He was, as my lady put it, the conduit, the only conduit, in fact, that we saw. In my submission, it's clearly more than fanciful that relief would be ordered against him. There was some suggestion from a learned friend, at least in his skeleton, paragraph 61, that some wrongdoing needs to be alleged against him. Not so. It's about whether he's sufficiently closely connected with the issues, as we've seen. And it was also in my learned friend's submissions before the short break, suggested that it was relevant that relief is sought against him and not other directors. I think the modern parlance for that is whataboutery, the suggestion that because we haven't joined other directors that Mr. Broadbent shouldn't be in the firing line in my submission is self-evidently wrong. The final point then is in relation to the offer. And this really is a short point. It wasn't successful before the ICC judge. She declined to decide it. It wasn't pursued before Mr. Justice Marcus Smith. It's unfortunately raised its head here. In my submission, it was right not to have been pursued before. Ultimately, the question is whether or not the offer was such that it almost amounts to an abuse or a misuse of the court's proceedings for a party to continue to pursue the relief, because what they're going to get is, because the rationale being that the offer is the best that they're ever going to get at the end of the matter. We've addressed this in our supplemental skeleton argument, paragraph 25. The offer was only sent on the 31st of July 2023. The petition had been presented, of course, on the 5th of December 2022. Mr. Broadbent had served his points of defence on the 27th of February 2023, after I think he'd had an extension in which he had denied any unfair prejudice at all. There was a CCMC on the 5th of May 2023. And as my learned friend said, I think disclosure was already in train. And the offer was not, as you would see in O'Neill, in the references we've given, to pay for the costs. So the suggestion being that it's clear and can be said that my clients should have accepted that offer because it was better than they could obtain at trial, in my submission, is clearly wrong. My learned friend tries to use hindsight to say, well, certain of the allegations have gone, so therefore it should have been accepted. That seems to be transmogrifying it into sort of a colder bank offer in terms of turning into an argument about costs. It's my submission that's just not the correct principle. And of course, the offer proposed that there would have to be an evaluation exercise, and it wasn't being proposed that Mr. Broadbent would pay any part of those costs, so the costs would get more. So my client was going to have to incur all the costs of pursuing the petition and the cost of valuation, and it said that he should have accepted, it should have accepted the offer. In my submission, clearly isn't a case where it can be said that the petition should be struck out for not accepting that offer. The reference to O'Neill is Authorities Bundle, tab 8, page 146. It's Lord Hoffman. I wasn't proposing to take you to it unless you wanted me to.
And you're very much on time and very much within time if we take the 1.5 day estimate.
May I just turn around for one moment? Nothing further from me, so unless you have any questions.
No.
In which case, you'll be surprised to say we're not going to give judgment here and now. You'll receive... Sorry, Mr.
My Lord, I just wondered whether I could respond in relation to points that are in the respondent's notice.
You must be able to, you're quite right.
I'm so sorry. I didn't
Yes.
Before I do so, and I don't intend to go outside the tramlines, there were certain points that were put to the court for the first time today which hadn't been prefaced with the skeleton argument or elsewhere in submissions this morning. It was said that the original shareholders agreement provided additional mechanics as to how an appointment could be effected. That had never been suggested to my knowledge before today, but it's an obligation on, well, it's an entitlement of Mr. Broadbent and Mr. Dixon acting together to effect the appointment. And in my submission, it more obviously relates to the original state of affairs when the company was being established, rather than several years down the line when one's talking about the rights that one has supposedly conferred by the nomination letter. I was criticised for not using the word market value. I did give various other synonyms. I'm not demonstrably shying away from the word market value, but it's a very elusive concept. It's I said the best price reasonably obtainable for the shares. Now, the market value would not be a straight line percentage of that, unless one was selling the whole company. There would be a discount applied in any valuation. And Mr. Haslam, when he talks about the market value of the company and there being a discount applied to that, is eminently right. It's the discount that would be applied in arriving at the price for the shares, bearing in mind all the various points that directors need to consider in arriving at the price. My learned friend was called upon to answer probably what was a question for me. What would have happened had this matter gone to trial and on the first day Magic had popped up with the pure dilution allegation? Well, our position would have been quite clear, and it's a position we've articulated before. It's not a pleaded allegation, and it couldn't fairly be tried by the court. Magic would be held and should be held to its pleading, and the evidence and expert evidence in particular that would be required to deal properly with that allegation is simply not there. It would be grossly unfair for Mr. Broadbent to be ambushed with a case of that nature at trial. And although there has been a hiatus caused by the strikeout application's success and the subsequent appeals, there's no application to amend, there's no acceptance that the pleaded case is narrower. And while I'm criticised for not making an outright objection to Magic taking the point about the pricing before Mr. Justice Marcus Smith, that isn't right. We took a point about it wasn't a pleaded allegation. We said it shouldn't be found by the court that Magic has this case that the ICC judge somehow did not deal with. And what it, on its merits, Magic contends it spells out of that, just simply is not a viable complaint. Something more and a lot more would have been needed had Magic been making the complaint that I've referred to earlier.
I'm not sure all these points are tied to respondents.
I probably move on. In terms of the respondents' notice, the court isn't being, in my submission, asked to let Mr. Broadbent off. There's no question, though, that Mr. Broadbent is not tarred with any culpability in respect of any of the matters complained of. He is, as I put in answer to a question from my lady, the conduit for communications from the company. He is not instantly, therefore, to be regarded as more culpable than any of the other directors who also represent the company. I'm not in any way suggesting that wrongdoing necessarily needs to be established in order to establish a target for relief, but without any substantive complaint about the actions of that individual. And as I say, this is a petition which complains about the misbehaviour of the company, alleged misbehaviour of the company. Without complaints about the conduct of the individual, the petition just doesn't contain the averments that would be relevant in order to fix liability upon Mr. Broadbent. And Mr. Broadbent hasn't been the subject of trial. It's not a question of the court looking at what might emerge from trial. My own friend promises that lots would no doubt emerge from trial. The petition just doesn't set out the basic allegations that are necessary. And the position in relation to the offer, just to correct my learned friend's point, the offer was a fair offer. It didn't offer the cost of the petition to the petitioner, but it agreed to accept no orders to costs between the parties in relation to the litigation. As regards the valuer's costs, those were to be shared equally between the parties unless the valuer saw reason to order otherwise. That's perfectly standard. The determination of an independent value for Magic shares in the company was of something of benefit to both sides, whether buyer or purchaser. And the valuer had the latitude, had one side behaved unreasonably in that process, to invite the valuer to make a different order for costs. Nothing extraordinary about that. And of course, even on my learned friend's chronology of how far this matter had proceeded, it was an 8-page petition and a CMC, and consideration of our defence. That's all Magic had really done. It had begun to embark on disclosure, but we were not deeply entrained in that at the date that the offer was made. In my submission, as I put it earlier, the offer was a fair compromise, fair and proper compromise, and offered everything that Magic could legitimately expect at the time it was made. And that includes recognition of the fact that, as the court has held already in relation to the unappealed allegations, a number of allegations that Magic makes are simply hopeless and have been struck out. And it wouldn't and should bear, wouldn't get the costs and should bear the costs of making those allegations, as opposed to my learned friend's suggestion that the court should not take account of those weak allegations and what has become of them in appraising the offer made by the court. Unless parties appraise their litigation rights properly, these sort of offers don't really work. Can't be the simple fact that Magic makes a series of bogus claims that justify it having an entitlement to its costs. And my client's compromise position on cost was an entirely fair one, coupled, of course, with the respect that he would give Magic in terms of the valuation date. In my submission, it was a fair offer and would have avoided a lot of unnecessary litigation in this matter, had it been accepted. Unless I can assist further.
No, thank you very much.
Thank you, Mark.
So we have indeed saved coming back tomorrow, so thank you all very much, and thank you for your very helpful submissions. You'll receive the draft judgments in the normal way electronically for you to point out our errors of English and typing. That won't, of course, be an occasion to attempt to re-argue the case. We'd be grateful if, at the same time, you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we expect to settle the points in the order that we make. Finally, although I'm sure everyone in court is well aware of this, I ought to remind you of the importance attached to the embargo. Breaches of it are still occurring, and those are taken seriously. But thank you all very much.
My Lord, may I just say I will email your lordship's clerk with the references to the transcripts
Please.
that your lordship asked about earlier. But I will do that this evening.
Thank you very much.
And apologies for my lord, I misspoke when I mentioned you said your name. Someone who's used to having his name mispronounced.
I can tell you that you can even find instances of the official law reporters swapping between Newey and Newey in the same report.